Okay, the last case on the docket, and prior to beginning the case, I'd like to introduce the panel. Obviously, Judge Cohen remains on the panel, and we have Judge Evander, and I am Judge Wallace presiding over this case. It's Home at Last Adoption Agency versus VM, and how much would the appellant like to reserve?
Judge Wallace, I'd like to reserve 5 minutes for...
Okay, all right, you may proceed.
Good morning. May it please the court. My name is Shannon Macklin Carlisle, and I represent the appellant, Home at Last Adoption Agency. Your Honors, reversal is required because the trial court misapprehended the breadth of your prior opinion, Home at Last Adoption Agency versus VM. The error is clear if you turn to the trial court's order on the final judgment in the second amended petition. And if you look at the second page of the order, the court specifically said, the father is under no legal obligation to provide support or visit the minor child. And Your Honors, in your prior opinion, you ordered that VM was under no obligation to abide by the erroneous Chapter 39 case plan. But Your Honors, that does not extinguish a father's independent duty to support his child or bond with his child. And so, just on the face of this order, reversal is required. There's a second part of this order that on the face shows that it's wrong, because if you look right above that erroneous ruling, it says that you ruled that the finding of termination could not be ordered due to lack of notice to the father. Well, that also is wrong, because you ruled that the finding could not be sustained because it was an erroneous Chapter 39 plan. And so those two issues right there demonstrate that this order needs to be reversed. The problem with the trial court's order is that it made the mistaken assumption that the petition had to be reversed because the child is a fluid being, and when the opinion came out, there was a passage of time between the opinion and when the facts that had occurred based on that hearing. And so there was an entire year that had gone by, or excuse me, 6 months that had gone by when the facts had happened, when VM had continued to not do anything and continued to not bond with this child or visit with this child or support this child when other people were doing so. And so when in the original petition, when the original finding of lack of abandonment, there was not sufficient evidence to find abandonment had occurred, that finding was affirmed. But then when the trial court found that there was new facts, he had a duty to be able to, there was a duty to be able to have another petition be able to be filed. So that was okay. And so it does not make sense that Chapter 63.0895 is a one-time shot. Of course the state was able to file an amended petition and have a hearing and have notice and have an opportunity to be heard. So VM had that opportunity, and it was absolute error for the trial court to misapprehend your opinion to think that he could not find abandonment. So,
just for clarification, you're talking about, in one breath, you were talking about a new petition, and then you're talking about a minute petition. We're talking about a minute petition, correct? It wasn't a new petition.
Yes, it was an admitted mistake that a new petition was not filed. But if you look at page 4 of the answer brief, even VM's appellate lawyer calls it filed a new petition. It was instead of a dismissal of the petition and a new petition being filed, the appellant amended its petition at the direction of the trial court.
Now, the
So instead of a new case number being filed, it was admittedly an amended petition.
Was the amended petition personally served on?
Yes, it was personally served on, excuse me, Your Honor, personally served on VM and his counsel. The only difference is that it didn't have a new case number and a filing fee was not paid. But in all other respects, it is the same as a new petition.
Well, and the new petition, or the amended petition, sought relief under Chapter 63 as opposed to Chapter 39, correct?
Absolutely, Your Honor.
Was there any relief requested under Chapter 39 in the amended petition?
No, Your Honor. It was absolutely tantamount to a new petition, but for the fact that it was called a second amended petition.
Well, it did include a reference to the father had abandoned by not doing the case plan, but then you also had that he abandoned by not supporting or visiting the child.
Yes, it was all new facts through new information all the way through, and including the fact that the trial court made a finding in his final judgment on the second amended petition to terminate the parental rights that the VM had not done anything that supported the child all the way through the hearing on the second amended petition.
Is it your position that the actions up to the first trial, not including the 6 months that occurred after the first trial and the time for the judge to rule in the second trial, is the actions up to the first trial where the judge then in effect ruled that there wasn't enough for an abandonment or for termination of parental rights, all of those facts are res judicata with regard to the first issue, and they should not be considered by the trial judge with regard to the additional 6 months?
I think it doesn't matter, because I think that even if those don't amount to abandonment, then the additional evidence that occurred after that first period of time is enough to equal abandonment. But with those, that's even more. But what the problem here is, the judge wasn't even able to reach the conclusion because he mistakenly and erroneously believed that he wasn't able to reach it.
Let's say you've got a 6-month period, a ruling, and then another 6-month period. Could you not have a ruling that while what happened in the first 6 months wasn't sufficient to rise to the level of abandonment, it could still be, in theory, relevant to whether subsequent to that, those actions constitute abandonment?
Yes, Your Honor, I believe it does. I believe it can. I don't believe it's irrelevant. I believe it's, while...
It could be res judicata, which was Judge Wallace's question. Then if it's determined, it's determined, but I'm suggesting that perhaps that's not quite so clear.
In other words, it's res judicata that the actions in the first 6 months were not sufficient.
Yes.
But can you consider the first 6 months in determining whether after 12 months?
Absolutely, yes, the portion is definitely res judicata, meaning you can't go back and find, yes, I've changed my mind, that now is abandonment, but that is relevant as to, okay, now, if it's been 3 years and you still haven't done anything, that can rise to the level of abandonment. And so in this situation, again, I believe that the trial judge misapprehended this court's prior ruling in determining that the Chapter 39 proceeding was, that VM didn't have VM did not have an independent duty to support his child, notwithstanding the erroneous Chapter 39 proceeding that this court ruled prior. And if this court does not have any further questions to me at this point, I'd like to reserve my time for rebuttal so I can answer the questions that are raised in response.
Morning. Morning. May it please the court, my name is Daniel Waking. I'm Assistant Regional Counsel at the Office of Criminal Conflict and Civil Regional Counsel for the 5th District, and I represent the father VM in this case. The court should affirm the trial court's determination from the March 16th, 2012 trial for two reasons. First is, as a matter of law, from the facts that were brought forward at that trial, finding of abandonment could not be sustained. Second,
On the amended.
Yes. There are two trials in this
Right.
case, essentially.
You're suggesting that even though the trial judge found abandonment, that was unsupported by the evidence?
No, the trial court did not find abandonment in either.
Because of how we read our opinion, but if you read the factual findings that he made, they say what they say.
Well, I would say that the first point is that regardless of if the trial court understood the Fifth's decision originally when it applied to the second petition, regardless of whether he understood that correctly or not, the facts of the case don't get to the point where any court could have sustained a finding of abandonment.
But if you look at the order, I mean, just the simple wording of the order, the father is under no legal obligation to provide support or visit the minor child. Clearly, that is contrary to the existing state of law in the state of Florida, correct? I mean, clearly, it isn't framed any more clearly than in that order, and I don't think we need to move any further than that.
Well, that gets to my second point, that I believe the judge applied the proper law in this case, and I recognize the confusion that may have been...
That's proper law? You think that's proper application of the law? How can that be?
Because in this particular case, I believe that that's the court expressing its findings in a confusing manner, rather than saying that father has no duty to express support for a child.
What's confusing about what he said?
Well, in this case, on the record, when the case was before the court for a rehearing in December of 2011, prior to the second amended petition being filed, the judge spoke to Home at Last's trial counsel at the time and suggested filing an amended petition, and went by essentially note for note the law as it stands. He talked about abandonment and read what the definition was.
It finds that the father VM has failed to pay child support or visit from the time of the child's birth through the date of the second termination trial. Now, that sounds like abandonment, doesn't it?
It would sound like abandonment in...
However, the father appealed this court's ruling, and then he goes on to talk about, that the father was not obligated to comply with any case plan, including support or visitation.
And I believe that's what the court was getting at in its ruling, was that he was not obligated to comply with any case plan here. He wasn't applying the...
That's fine, but that doesn't stop there. He still has, obligations as a father.
Yes, and
Did you read our opinion and come away with the sense that what we said or intended to say was that this father had no obligations vis-a-vis the child?
No, I did not read that in the initial VM opinion.
Okay, so you would agree that the father had an obligation independent of any case plan, which was erroneously imposed, but that he had an independent duty to, independent of any case plan, to support and maintain contact with the child. Would you agree with that?
I think the statute requires that when the father is able, and what the court is getting at in its decision here is that the father wasn't able to because the child had been illegally placed in another state by the appellant in this case.
Well, he wasn't able to what, visit?
No, the child was placed in Massachusetts when she was 1 week old.
Didn't the child didn't the trial judge set up a visitation schedule where the VM, your client could see the child every other Saturday in Florida?
Eventually, there was 8 hours a month allowed if he were to pay for someone to visit those, to supervise those visits. My client was found indigent, which is why we're on the case.
But he's making $2,000 a month. He could either find out what the costs were. Well, let me ask you this, is there any evidence in the record what the costs were?
No.
So we don't know if it's 50 cents an hour or what, and we don't know if he asked for a waiver of costs.
No, and we don't know,
You know he's making $2,000 a month.
at the point of the second trial, I believe. I believe that's
Wasn't that
accurate.
also the first trial that he had this, didn't he testify at the second trial, he had the same job that he had at the first trial?
He's had the same job for a long time, but at the time he filed his initial paperwork regarding indigency, he was, I think, making $195 a month with food stamps. He had been incarcerated for 4 months prior to the child being removed, based on allegations from the mother that he had abused her, that the state attorney's office found didn't have enough merit to prosecute eventually, but in the meantime, he was held on $350,000 bond and wasn't able to get out. It's not coincidental, in my opinion, that it was the day he was scheduled for a bond hearing and his bond was reduced to
$350,000 bond?
$350,000.
First-degree misdemeanor, then.
It was a second-degree felony because the mother was pregnant at the time. But the day that the bond was reduced to $5,000 was the same day that the appellant moved the child to Massachusetts, knowing who the father was, knowing where he was.
Bond?
I'm sorry?
Did you make the $5,000 bond?
He did.
And the prospective parents were willing to, at their expense, provide transportation to the child to facilitate the child being here in Florida from, I guess it was Milton, Massachusetts, for the visitation, correct?
That was what was alleged by their counsel.
Okay, so there was no cost associated with your client actually transporting the child from Massachusetts to Florida for the 8 hours I think it was every other week, correct? Every other Saturday?
It was 8 hours per month. It may have been 4 hours twice a month, but it was a
This is
total.
good, except the trial court found that, there was effectively no obligations on him to, to support or see this child.
Well, and that's correct. In this particular case, where he wasn't able to, there were no requirements that he...
His ruling is that the 5th District Court of Appeal ruled that the father was not obligated to comply with any case plan task, including supported visitation. And so he has no legal obligation to provide support or visit the minor child. Therefore, the child is not abandoned. So it's got nothing to do with inability. It simply has to do with the fact that the trial court interpreted our opinion to say that that a father has got no obligation to visit with or support his child.
I think it could be easily read that the father is under no legal obligation to provide support or visit to the minor child in this case. And in this case, the facts are specific that he was taken by the Home at Last agency with no authority to take the child, but for the mother signing surrenders, but knowing that the legal father objected to this, and knowing where the legal father was, still told the legal father that he had to sign for the
But none of these
putative...
findings were made by the trial court judge. This is completely speculative. We read an order, the order is silent as to all of these issues that you're raising, and you would have us somehow read into the order that the trial judge wrote and make these findings that benefit your client when they simply don't exist.
Well, all of the facts are in the record, and that was what the trial court based it on.
Well, let me ask you, as far as if the trial judge had made a finding that he could not afford visitation, would that be supported by the evidence? Because the evidence was he's making about $2,000 a month, and was there any evidence on, I think I already asked you, on the visitation costs?
Neither side presented evidence as to the visitation costs.
So if we know he's making $2,000 a month, and we have no evidence of visitation costs, how could a finding that your client couldn't afford visitation be supported by the record? There'd be no evidence in the record to support that.
record was supported based upon testimony from my client that he was told by prior counsel, he's had several attorneys on this case, that it would be best not to pay child support or go along with their visitation when it was a situation where they took the child in the way that they did.
Well, that doesn't go to ability to visit, does it?
Well, if he is not an attorney, he's indigent and unsophisticated, he's relying upon...
It's indigent, but the record reflects $2,000 a month income and nothing on costs. So, I look at the child support guidelines, and they say someone making that much money can pay several $100s of child support. So legislature's determined that he has enough money to pay child support. So, you're arguing that the trial judge was saying that under this record, he didn't have the ability to visit or support, and I'm asking where on the record that is, because the only thing I'm seeing in the record is that he did have the ability to do it.
I think those are two separate issues, the ability to visit and the ability to support. The ability to support in this case would be based upon the presumption that the Home at Last and their caregivers were entitled to some kind of support in this case.
The child that's entitled to the support.
I would agree. And the child is entitled to the support, and where the court dismissed in the first case, or should have dismissed in the first case, according to the VM case already on the record, the result should have been, upon dismissal, that the child was returned to the father at that point.
Why the father, not the mother?
Because the mother had already signed surrenders.
Right, but at that time, can't she revoke her surrender if the adoption's not going to go through?
She could have, but she didn't.
All right, so it means that the child wouldn't automatically go to your client.
It wouldn't have automatically gone to my client, but it definitely wouldn't have, she would have stayed where she is. And if the child wasn't staying where she was, then my client would have had a duty to support.
So whatever
in that
might
case.
have, what might have occurred didn't occur, and we're dealing with the landscape as it exists now.
Well, I think we need to look at it as what should have occurred. And what should have occurred was the child being returned the child should have never left in the first place when they knew who the father was and that he was the legal father and where he was and that he wanted the child.
Is your argument that because this should have gone in some other way and didn't, that the obligation to see this child and the obligation to support the child no longer exist?
That the obligation to provide child support to the current caregivers did not exist. Surely the requirement to support the child existed, but that would have been fulfilled had the child been placed with the father like she should have been from the get-go, or like she should have been after the first trial, or like she should have been after the second trial. The separate issue is visitation, and in this case I would argue that he also wasn't able to, in the situation that he had, based upon the illegal taking by Home at Last and placement in Massachusetts, and even if they were willing to allow the child to come down and would pay for that, he still had to pay for visitation under that offer. That offer never manifested itself. He had counsel telling him it was a bad idea. He had filed a motion for time with his daughter that was never ruled upon prior to either of the trials.
And the trial judge implicitly ruled on it by setting a schedule of 4 hours every other Saturday? I mean, isn't that a response, in essence, to a motion to set up a time schedule?
It wasn't a direct ruling on his motion, but I understand what the court's saying.
Did the trial judge at the time of the original motion have ordered the department to file a Chapter 39 proceeding, which would certainly have impacted upon your argument that the child should have gone directly to the father?
Well, the department was never involved.
But the trial judge could have ordered the department to get involved and file a Chapter 39 proceeding.
I don't believe that the trial court had that authority under the Chapter 63 petition that it was dealing with.
Yeah.
Couldn't the father, even though you're disputing the fact that the father should be under no obligation to pay for financial support to the child that would go through the prospective adoptive parents, could the father have actually escrowed money that would have been the equivalent of the support for the child, to have that money put away, realizing the child was not under the care of the father, but the father still had responsibilities to support the child, even if the child had lived with the father.
I would say that the father essentially did that by, the record shows that he was living with his parents, that he had purchased a new vehicle that was going to be necessary for taking care of the child, and that he did that in a sense rather than putting it into a formal escrow account.
You know, I did the same thing. I bought a nice car. I did it for my kid.
You got to get around.
Yeah.
All right, so if I understand your argument right, you'd agree that it'd be wrong, whether the trial judge did it or not, it'd be wrong to say that the father had no obligation of support or to visit based on our ruling.
Where the father was able to, the father would have.
And your argument is based on the evidence of trial, he did not have the ability to do so.
Yes.
The second DCA had that JCJ opinion. Are you familiar with that?
I'm not.
Okay. Because it seems to be a fairly similar fact situation where litigation went on with this child for 3-4 years. And in the JCJ case, there were two different opinions, one from the second, one from the Supreme Court. And meanwhile, the child had been with the prospective adoptive parents from about a week after the child's birth. And the father raised the same argument that you're raising here, that with all this ongoing litigation, he shouldn't have had this obligation of support. And the second disagreed and said, you know, the obligation to be a parent exists regardless of whether there's this ongoing litigation and the child was with prospective adoptive parents. I mean, what's your feeling on that?
Based on the courts informing me of the facts in that case, I think the distinguishing factor here is that Home at Last took the child illegally, that it wasn't something that was approved by the court, that there was no following of anything in Chapter 63, there was no following of ICPC. They knew where the father was at, they knew he didn't want it, and intentionally sent the child there 8 days after she was born, knowing how the father felt, without getting a court order to do so, and without any court supervision. There has to be at least notice to the court 2 days after they make the placement. If you're going out of state, there has to be ICPC involved, and there's no record to support any of that. The difference in this case, I think, is that Home at Last didn't do what was required to do to place the child where they placed the child.
If the child was illegally taken, how long is that a defense to any claim of lack of support or contact by your client? Is that 6 months, good for 6 months, 8 months?
As long as...
10 years? I mean, how long does he get to say the child was illegally taken before his obligation of support or his obligation to communicate with the child kicks in?
I would suggest that it lasts as long as the child is in that illegal placement. In this case, it should have been remedied at least after the first trial, and the child should have been returned at that point. That's part of what the court should have ordered, and should have ordered in this case, is that the child should have been returned.
Under your argument, where does the best interest of the child kick in?
In the Chapter 63, which deals with dismissal, the statute talks about best interest of the child once the case has been dismissed, having to do with returning the child immediately and returning the child with a reasonable case plan put into place to ease tension on the child if there's shown that there's been a bond to the caregivers. I think that's the only place where best interest could be applied in this area. So once the dismissal goes in, that still is there. However, in this case, it's our position that the court should have ordered reunification with the father immediately without a case plan, due to the fact that it was an illegal placement, due to the fact that he is the legal and biological father, and due to the fact that he has a constitutional right that had been violated up to that point.
Well, would you agree that at the time the trial judge, if the trial judge had ruled, I find no abandonment, that he could have, placed the child with the mother, the father, or, and I think the statute says, Chapter 39 proceeding can be filed. So you're just assuming that the only choice the father had, the court had when when he found no abandonment, was to place the child with the father, but that doesn't seem to be the law.
I don't believe that at that point, the court could have found, could have had all of those options. I think that the court could have placed with the mother if the mother had asked for it, but it's under 63-089 subsection 5 dealing with dismissal in this case, where it says that under subsection B that if there is a bond with the current caregivers, then best interests would apply in factoring a reasonable case plan for reunification. But that's the only situation, and the idea would be that it would be best interest of the child and getting the child back to the parent as soon as possible.
Counsel, you're out of time.
Thank you very much.
Thank you. And Ellen has basically 10 and a half minutes.
VM continues to look at this case in the best interest of VM and not in the best interest of this child. And as all of you recognize, this case and the courts look at the best interest of this child. He also continues to complain that he is not able to do what he can to help this child. And it doesn't just take money. He could write a letter, he could send a package, he could send a picture, but he hasn't done anything. And as this court has recognized, the face of this final judgment demonstrates that VM has failed to pay child support or visit from the time of this child's birth through the date of the second termination trial and to date. And Home at Last asks that this court reverse and remand with directions to the trial court that it enter an order finding that its findings are sufficient to find abandonment. Thank you.
If, let's assume that the trial court did that, and they wanted to appeal the sufficiency of that evidence. Do they have the right to do that then? We remand it, the trial judge enters that order, and they want to challenge saying, well, you know, you've got these issues in terms of his ability to comply. And we think that the evidence is insufficient to support those findings.
Well, perhaps he does. Or perhaps the court should remand for a further evidentiary hearing for all the evidence of continued abandonment to date.
Thank you. We're in recess.